like the chairman said, in October 2004, the IRS announced a new policy that it would only seize structured assets that came from an illegal source. During our hearing last year, Mr. Koskinen, you agreed with Congressman Holding that if the IRS seizes assets of a person, they could go to court and argue the government doesn't have cause if the document doesn't show the funds came from an illegal source. You said, and I quote, "Private citizens should have the ability to do that." A few weeks later, though, you said in a letter to the committee that, quote, "Decisions above what specific evidence is included within a warrant affidavit ultimately falls within the discretion of the U.S. Attorney's Office in consultation with law enforcement agents. In the interest of operational considerations, the Assistant U.S. Attorney and case agents may have sound reason for not including certain evidence in a seizure warrant affidavit involving a legal source investigations. So the evidence of a legal source may not be included in every seizure warrant affidavit." I'd like to enter your letter and the letter that the committee sent in response into the record, Mr. Chairman.
Without objection, so ordered.
Thank you. I take it that your revised version is correct?
The revised version is correct, but I think the original statement was correct. What I said was, under the process, no matter what the evidence is in there, anyone whose assets are seized has the right to, in fact, go to court. And, in fact, that's the distinction of if they come to us and it's an administrative proceeding, we can, when they make a petition, remit the funds directly. If they've gone to court or the process has gone to court, it's within the U.S. Attorney's jurisdiction. And that's what my letter says, that it's up to the U.S. Attorney as to how much evidence is in the case, but the citizen, as I said at my hearing, has the right to come to court and challenge the validity of the seizure, challenge any other claims that are being made.
Well, citizens have due process, of course.
Yes, of course.
Absolutely. Thank goodness for the Constitution. But, Mr. Weber, this question's for you. You are the one implementing this policy. It is the IRS. If the IRS does not include evidence of that money came from an illegal source in an affidavit, shouldn't the property owner be able to argue that the affidavit was deficient and his property shouldn't have been seized?
So it's not required, Congressman, for the specific allegations of illegality of the source of funds to be in the affidavit. So there are circumstances where the agent and the prosecutor make a determination that the source of funds is tied to an illegal activity, and those are the only cases and investigations that my agents are allowed to work with respect to structuring seizures now. But there may be a decision by the prosecutor working that case that they're not going to include certain evidence and information with respect to the illegality within the affidavit. That doesn't necessarily mean that that case is not an illegal source structuring case.
So without requiring that information, you all can present an affidavit to any citizen without proof or documenting that it came from an illegal source. So that's what you're saying?
Yeah, under our current policy.
Under your current policy, you could go after any citizen and not provide in the affidavit that it's from solely an illegal source.
Under the current policy, yes, there's no requirement that that
Unacceptable.
information would be detailed in the affidavit.
I'm not a law enforcement person, but there are cases.
The question is Mr. Weber.
Okay,
That's interesting. Okay, I have another question then. The IRS's October 2014 policy includes an exception for exceptional circumstances. What happened to due process? What counts as exceptional?
So a couple of things, Congressman. So in the year and a half that policy has been implemented, we haven't had one situation where a special agent in charge has requested from headquarters the exception to be applied in their case. So we have not had one of those cases. In my view, and what we've told our field offices, we have 25 field offices across the country, and we've told our SACs that it would be in the rarest of situations that we would approve, and that has to be approved by Washington and executive and headquarters. Under the rarest of situations, if it was a case that hypothetically could be connected to terrorism, where there's information or evidence where the property may be going overseas, we may not have the specific evidence or proof that it's tied to terrorism or illegal activity, they've committed the crime of structuring, but that property is going to be heading over to another country, that may be a situation with the approval of the U.S. Attorney's Office and the approval of a headquarters executive that may be approved. We haven't had a single case in the 1.5 years that the policy has been implemented.
Okay.
And I don't think there'll be
One
many
quick
of
question
those.
for Mr. Blanco. In my prior questioning of the folks that testified, I submitted in the record an email that showed that a U.S. attorney seemed like was giving harsher penalties in a settlement agreement based because an individual went and spoke to the media. Is there any policy in the Justice Department that makes harsher penalties to anyone that you are investigating or researching if they speak to the media?
Not that I'm aware of.
Okay, thank you.
Mr. Crowley.